Hello, everybody. So now that we have determined that students can be compelled to attend school, um, let's look at the instructional program that schools offer and see where the authority lies in our instructional programs. And so in this chapter, we're going to look at these basic headings here. Most of what we're going to talk about here in the next 30 minutes or so is going to deal with curriculum and what all is entailed within the curriculum. After that, we're going to take a short time, maybe about 10 minutes or so, and look at these other areas: censorship of textbooks, censorship of library books, course content and teaching methods, promotion within schools, diplomas, grade reduction, homework, and then we'll end with sex education. As an overarching theme here, though, I want you to keep in mind this term here from page 53 of Alexander and Alexander, and this is judicial deference. And basically, what we're saying here is that the courts are highly respective of the professional nature of educators and the school systems in general. And this doesn't necessarily just go to common ed, it also involves higher ed. And as a result, the courts are reluctant to get involved with all the day-to-day routines of common education. Your book gives a couple of examples here of just how judicial deference works. And there were a couple of medical students who were dropped from their programs for academic reasons, and the professors had adequate support showing that the academic reasons were legitimate. And the courts refused to question the professionalism of the educators. So keep that in mind as we go through here, dealing with um, the curriculum and the instructional program in general. Because what we're going to see is the court's reluctance to get involved, and there are going to be some narrow rules that help guide decisions. And as long as states and as a result of that, school districts, school boards who set policy abide by these general guidelines, what we're going to see is a reluctance for the courts to step in. So let us start with the curriculum, okay? So we have some quotes here. Local school boards have the power as delegated by statute to enforce reasonable rules prescribing a specific curriculum. As long as school boards have the authority to act in certain situations, their rules are reasonable and they act in good faith, their actions will not be overturned. So there are a couple of places in this that I put policies. Now, Alexander and Alexander don't talk about policies, but I think that that's implied in there. And one of the things that I have seen in my work with schools is a lot of times the absence of policies. And so I encourage you, as you work through this, that you have policies and you review policies, especially if you continue on and become a certified superintendent, that you continue to keep policies in mind. And so some of the first policies that you should have in your book are policies referencing state statutes that give the board its authority and give the school district its status as a district and so forth. And so the second bullet here, as long as school boards have the authority to act in certain situations. So when the board creates policies regarding all these different areas that we're going to talk about in the instructional program, my recommendation is that you reference back to the statute that gives the board that policy to do that. Okay, and obviously policies are kind of like the jurisprudence of cases that we're talking about here. There's going to be large policies and then policies that will follow after that. Um, and then you get into regulations, but we don't necessarily, we're not talking about regulations here, we're just talking about policies. But as whatever policies you have that allow you to do certain things, such as create a curriculum, create graduation requirements, um, grant a diploma. All these things need to reference back to statute that gives the board that authority. And in the last presentation, I gave you a link to Chapter 70, which deals with education law in the Oklahoma Constitution. Okay. So again, we said courts will generally hold in regard to the interests of students, parents, teachers, and the state when looking at curriculum. Okay. So they're weighing these four different stakeholders when looking at it. But keep in mind what I said, that judicial deference is going to apply here. The rule which comes nearest to being generally applicable is that the course will hold in favor of the courts, I should say courts, not course, will hold in favor of the expansion of knowledge. In other words, rules that seek to contract the spectrum of knowledge or restrain the full expanse of human understanding and inquiry will generally be rebuffed by the courts. Chief Justice Earl Warren stated that society is best served when there is a wide exposure to truths and an unlimited exchange of ideas. Thus, the classroom is viewed as an intellectual marketplace protected by law. So these are some overarching ideas in talking about curriculum. And so here so this explains why courts are reluctant to withhold books, withhold textbooks, censor, in other words, not necessarily withhold, but censor these things because of this idea of contracting the spectrum of knowledge and restraining the full expanse of human understanding and inquiry. If the courts feel that something is too limiting, then the courts will generally rule against that. Okay, so just keep that in mind as we go through this. So the first thing really here in curriculum, and this is a good case because this gives you an example of how things continue to change and over time. What happens when the court generally makes a ruling as a result of the concept of test cases? What happens is we see test cases start popping up and trying to interpret the court's rulings in testing the limits of those rulings. Okay, so I'm sure everybody is familiar with the Scopes monkey trial. The Scopes monkey trial came out of Tennessee in the 1920s, and a teacher was teaching evolution and ultimately was fined was found guilty because the law in Tennessee at the time said it was against the law to teach evolution. The teacher continued to teach, was found guilty, and forced to pay a fine. This, of course, brought William Jennings Bryan and Clarence Darrow out and became known as the Scopes monkey trial. That law actually stayed on the books even after that course until 1968. And in 1968, there were two states that still had law on the books dealing with teaching evolution. And in Arkansas, in the case Epperson versus the state of Arkansas, the court finally ruled the unconstitutionality of laws that made it illegal to teach evolution. So what I want you to see here is how this, in essence, then evolves. So if you can't teach, or if the state then has to teach evolution, then those who are against evolution are going to start finding ways to get around it. And so you see in a clear pattern here, we see some in the 80s, we're going to see some in the 2000. The next slide, we're going to see some more in the early mid-2000 on how the courts are ruling because people are legislatures are passing laws and districts are doing things based on the most recent ruling. So in 1968, the Supreme Court said it's unconstitutional to have a law that says you cannot teach evolution. So then what happens is the concept of creation science comes into the education arena. And again, we're going back to Arkansas in the case of McLean versus Arkansas Board of Education. The district court in Arkansas in 1982 ruled that creation science is not a science and rather it is a religious doctrine and therefore could not be taught alongside biology in the classroom. And notice here a couple of distinctions on this page. This is kind of a side note. When I give you just the year, this is a case that's gone to the Supreme Court. When I give you a circuit, this is a case that's gone to the appellate courts. This particular case went to the Fifth Circuit Court of Appeals, one level below the Supreme Court. And then here in this, we're talking about the Eastern District of Arkansas. So this is the district federal courts, okay? So that's the distinction between these cases. And what happens when a case is at the district level and somebody loses, McLean could have appealed, but you can't appeal just because you lost. You have to appeal for certain reasons. Maybe it's procedural reasons or something, or there was, I don't know, whatever. You can't appeal just because you lost. You have to have a reason. And the next court up has to have faith that your reason is a legitimate reason. And if it's not appealed or if it's not accepted up, then the ruling of whatever court is going to be accepted for that region. Okay, and so this one looked like it was a pretty clear-cut case. We're not going to give any more on creation science. So as of 1982, creation science was not a science. But that was in the district court. So in Louisiana, though, we still see a law in the books that required a balanced treatment of evolution and creation science to be taught in the public schools. And this case went all the way to the Supreme Court, and the Supreme Court ruled that the law saying an equal treatment or a balanced treatment of each was unconstitutional. So even then, it does not end, okay? So in the next case, this case is out of Louisiana because we're talking about a parish board here. Freiler versus the Tangapoa, and I probably mispronounced that, but it's fine. Parish Board of Education ruled that putting a disclaimer that teaching evolution was not intended to influence or dissuade them, being students, from the belief in the biblical version of creation in textbooks was unconstitutional. So you can see how we're evolving here. In the 82 and 87 cases, we were trying to teach creation science. We're beyond teaching creation science by 2000, simply putting a disclaimer saying that the evolutionary science is not intended to dissuade students from biblical version of creation. And even putting that disclaimer in was considered to be unconstitutional because of the Establishment Clause of the First Amendment. Two more cases involving the curriculum here settled within the last 10 or 12 years or so. Kitzmiller versus Dover. I remember when these cases came down. In the Dover case, this is a district court in Pennsylvania. In 2005, the court stated that the district could not have biology teachers to use an intelligent design reference book and then refer to gaps in the Darwinian theory of evolution. So here we're going to try to bring in intelligent design and teach it from as a point of reference to show that there are gaps in Darwinian theory. And again, the courts ruled against them. Um, in this case, I believe that it was the school board who who wanted to put intelligent design in, and Kitzmiller sued the school board and said it was an establishment case. And then in 2006, the 11th Circuit, this is the appellate court in Selman versus Cobb County, this is out of Georgia, stated the district could not place stickers in textbooks that read, and the district is trying to put this statement in the textbook, this textbook contains material on evolution. Evolution is a theory, not a fact, regarding the origin of living things. This material should be approached with an open mind, studied carefully, and critically considered. So here you can see that it's not even using intelligent design or creationism in the context, but clearly this again was seen as an establishment practice. And we're going to get into this in a much bigger aspect when we talk about church and state, but here keep in mind that the school, the public school, is acting as a branch of the government because we are a part of the government. And so the constitutional amendments apply to us thanks to the enumeration of the amendments to the 14th Amendment, which we talked about. As state entities, we cannot prohibit the free exercise of religion, or we cannot establish a religion. And so here what we see are school districts trying to establish religious beliefs by doing these things. So there's a little bit of background on evolution. A couple of slides here, actually just this one slide, on English language instruction. And here's a big case for you, Lau versus Nichols, 1974. This case came out of San Francisco, and there were over 3,000 students in the school system who spoke Chinese. And the district was only offering assistance to 1,000 of the students. And the courts came down and ruled that this violated Title VI of the Civil Rights Act. And then that same year, in 1974, the Equal Education Opportunities Act required the schools develop appropriate programs for limited English proficient students. And what we typically see now is that court rulings support student programs in trying to bridge these gaps. And I've been in schools working with school districts around the country where we see issues with this. There were a series of cases, the Castaneda cases, that basically developed 3 queries for satisfaction of the EEOA, the Equal Educational Opportunities Act. And these cases stated, or were asking these questions to see if the school's programs are appropriate for ESL students, English as a Second Language students, or LEP, Limited English Proficient students. So the questions are, is the school district's program based upon recognized sound educational theory or principles? Is the school district's program or practice designed to implement the adopted theory? And has the program produced satisfactory results? So if those 3 questions are answered in the affirmative, then the school is considered to be okay as far as its English language program. So Lau versus Nichols, big case involving second language acquisition. Another area, our last area under curriculum, deals with academic freedom. Academic freedom here in the sense of teachers. So what do teachers have the academic freedom to teach in their courses, and what kind of materials can they use in their courses? So here what we see is, and in the sense of what you teach, what can you say even to a great extent as a teacher in your classroom? So here we see a teacher has to balance his or her freedom of speech as a citizen with that as an employee of the state. Okay, so in your school district, you're an employee of the state. Speech exercised in public concern is protected, but speech about a private matter is not a protected right and can be regulated by the school. So keep that in mind. These are things that you may very well deal with. As a principal, I've dealt with these things. It's sometimes surprising the things you have to deal with, but I have, and it's all good. It comes out, it works out generally. In the case of Connick versus Myers, the court stated, here's a good quote for you, we hold only that when a public employee, you, the teacher, speaks not as a citizen upon matters of public concern, but instead as an employee upon matters of personal interest, absent the most unusual circumstances, a federal court is not the appropriate forum in which to review the wisdom of personnel decision taken by a public agency allegedly in reaction to the employee's behavior. In other words, if you get fired, the courts are not going to hear your case. Okay, that's the bottom line of what the court is saying in Connick and Myers. And then finally, the last thing here on academic freedom. So just work with your teachers. Again, acting as a public agent, public speech is fine, but it's the private concerns, the private matters, or the personal interest that you are using your position as a public employee to express personal interest. That's where things get murky, okay? And so just keep that in mind when you're working with teachers. Finally, the teachers do not have carte blanche in selection of learning materials, especially if there is a policy in place, should say if. Here again, we're talking about policy. Most school districts have policies in place on the use of materials, whether it's a video, whether it's all the way from adopting new materials or using materials. Policies are in place. If policies are not in place, do some searches on Google and find some districts that have policies and get some policies for your district. So, again, we go back to judicial deference here. We're going to look at censorship in a couple of areas here real quickly. Censorship of textbooks and censorship of library books. And here are a few books that your text mentions. Animal Farm, Dr. Zhivago, The Rights of Man, Uncle Tom's Cabin. More recently, Harry Potter, Uncle Tom's Cabin again. Apparently, that made an impression on me. I remember reading that a few years back. The Adventures of Huckleberry Finn and many others that were in there. Books have been questioned for the grounds on content and on the grounds of religion. And in general, courts are going to agree with the school on how they approach this, but again, there has to be policy in place. And there are good policies out there that talk about the process of questioning textbooks and or library books. Okay. Speaking of library books, school boards have a lot of discretion here also. 1972, the United States Court of Appeals for the Second Court held that school board had the discretion to remove books from the library simply because they were without merit either as works of art or science. So what the board has to do here to pull a book out of a library is to show that it has no merit, it has no contribution to art or science, and if they can do that, the court's going to support the decision. They also can weigh the local standards against what is in the book. The big case for looking at library books specifically is the Pico case. Okay, the Board of Education, Island Trees Union Free School District number 26 versus Pico in 1982. And here in this case, we're saying boards had the freedom to establish and apply their curriculum, but they could not strangle the free mind and limit youth in acquiring important information which will allow them to become responsible citizens. So in the PICO case, what came down is the court looks at the motivation of the board. Okay, if so I have here reason or motivation is the key. If the reason for censoring a book is disagreement with ideas, then it's unconstitutional. If the reason for censoring the book is pervasively vulgar or obscene or solely because they were educationally unsuitable, then the court is going to rule that it's constitutional. In the PICO case, there were a group of local parents from a conservative group that got a list together, and they took the list to the school board, and the board removed the books, and they lost the case. And they said that it was not a suitable reason to move the books. In other words, the court or the board did not have a legitimate reason. It was acting in the wrong interest for the wrong reason. Okay, it's the first reason there. In other words, it was simply a disagreement over the ideas in the books. So that's the rules for censorship of library books. The PICO decision. It all deals with motivation of the board, whether they agree or disagree with the ideas, and whether the ideas in the book are educationally unsuitable or pervasively vulgar. So course content and teaching methods. Here what the textbook is saying is that you as a teacher, the school board has a right to regulate the course content. Of course, that's part of the curriculum, obviously. And the teaching methods. In other words, if the teacher or the school board who gives the authority to the superintendent, who gives the authority, passes it down to the principal, and the principal says, we want to do stations in the elementary school, then you do stations in the elementary school. Okay, this kind of goes back to academic freedom a little bit. If you say, we think the best way to teach this content to our students is through team teaching, and the principal says no, team teaching is not good, then you have a right as a principal to say that, and those teachers have to listen to you. Okay, and consequently, if you look and see that you have somebody who is a certified Algebra 1 teacher, and for some reason they just picked that up, they're really their true love is history, and they have all these history certifications. You have a right as an administrator to require them to teach Algebra 1 if it's on their credentials. Okay, so this is just getting into the curriculum in that aspect of you as administrator being able to dictate certain things such as teaching methods and so forth for your staff. Finishing up here with a few things about students' promotion. Here we're talking about promotions from one grade to another. Again, the courts have generally allowed schools to make these rules. So the court says states and subsequently school boards may make rules for promotion as long as they are reasonable and not capricious. This allows for the Reading Sufficiency Act to be constitutional. We're going to talk about that a little bit at the very end of our class. And whether something's constitutional doesn't mean that it's necessarily good for the benefit of most. But that is why the courts have allowed states and subsequently boards to adopt those rules that say you cannot pass the third grade if you cannot pass the reading test. That's also why states are allowed to have rules like Oklahoma that says if you don't pass your 8th grade reading test, you don't get a driver's license. Okay, so it kind of goes along the same thinking there. Diplomas. School boards, through the power of the state, again, have the authority to grant diplomas upon successful completion of an educational program. The requirements, again, are set in policy and cannot be unreasonable. Once completed, a student has a property interest in the diploma, and the school district leaders may not withhold the diploma for other reasons. So a couple of things here I want to highlight on. First of all, again, we see that phrase set in policy. Okay, your policy should dictate what the expectations are, the minimum expectations for a student to earn his or her diploma, and that needs to be in policy. Now, the question is, could you go beyond what the state requires? And as long as it's reasonable, the answer is yes. There was a case that Alexander and Alexander talked about, I believe it was in Pennsylvania, where a district required students to do 60 hours of community service and explain the rationale behind that. And the court supported that before students could get diplomas. That's certainly above and beyond what we normally think of as requirements for school diplomas. And then again, that last bullet, the students have a property interest in the diploma. So you can think of that policy as a contract. So as long as it's a legitimate contract, students have an interest in that. You can't take that away from them. And then it says school district leaders may not withhold the diploma for other reasons. The most common thing I see here is when districts try to withhold the diploma for lunch fees or textbook fees, something to that sort, which probably would be illegal or unconstitutional, in my opinion. But not being a lawyer, I don't know, but that's just my thoughts on that aspect there. Grade reduction. Typically what we're talking about here is unless it's completely academic related, you cannot reduce a student's grades as a disciplinary action. For example, we saw a couple of incidences in the book where students were suspended, and as part of their suspension they lost part of their grade. Even though their suspensions were valid and for valid reasons, the reduction in grade was considered to be unconstitutional. So the use of academic sanctions for non-academic misconduct is considered to be arbitrary and capricious. If academic penalties have an academic connection, on the other hand, these are constitutional. For example, a student who misses 10 or more days in a class per Oklahoma statute can receive no credit for that class, and that's a constitutional or state law. And so if districts wish to uphold that, that will be upheld in court. Okay. Extracurricular activities, we will talk about this again later on when we get into students' rights under freedom of search and seizure. But for now, just know there is no constitutional right to participate in an extracurricular activity. Therefore, as a result, districts may institute measures to participate in these activities, and as we will see later, include such things as random drug testing. For example, what we're talking about here is districts can require GPAs to be a certain point, number of days missed to be at a minimum, and so forth. So, and I just had to add this. This is a quote. This is not from me, because I thought it was interesting that one district required athletes to have a 2.0 or higher GPA, which was upheld, and then another district required cheerleaders to have a 1.6 or higher that was upheld. And if anything, you would have hoped the courts had declared that unconstitutional because it was too low, but apparently they thought the 1.6 was fine. That's a little frightening. Homework. Districts can issue homework as long as it's not very prescriptive in the sense of saying your child will read from 7 to 9 every night. At that point, it becomes unconstitutional. But simply to have the expectation that a student will do some practice work, some guided practice at home, is certainly constitutional. And finally, the last area is sex education. To put this easily, straightforward, sex education is constitutional. There is nothing in the law that says it is unconstitutional. Uh, Questions start to arise about sex education when it becomes mandatory. My personal belief, it's probably a good thing, but that aside, because we're not going to take personal beliefs into um, public schools here for the most part. The best solution, whether it's a sex education class as a whole or sex education as a part of another class, such as a family and consumer science class or a health class, the best solution here is to offer students an opt-out option so that they can miss class during those particular times and do some substitute work completely equal to what they were missing and not be penalized in any way. And with that, that is a quick overview of the curriculum. So you can see the curriculum took in a lot of different things there, but generally what we see, as long as school boards have policy that refer back to laws that are issued by the state showing that they have the authority to do what they're doing, courts are generally going to leave schools out or decide in favor of schools, in other words, when it comes to curriculum in the various areas that we talked about in curriculum. So that's kind of an overview of just getting us started here with a look at courts, a look at attendance in schools, and a look at the curriculum. We're going to move in now over the next few weeks and start looking at students specifically and the rights that students have. And the first thing that we will move into next is dealing with students when it comes to the freedom of speech and expression.